Despite overwhelming evidence of wrongdoing, the doctrine of qualified immunity protects law enforcement officers from facing consequences, making them immune to accountability. According to the Equal Justice Initiative, the Breonna Taylor case and questions about qualified immunity, uploaded in 2020, 26-year-old Breonna Taylor served as an EMT with dreams of becoming a nurse and starting a family. Breonna and her boyfriend, Kenneth Walker, fell asleep in bed, as usual, on March 13th. Shortly after midnight, a loud bang awoke them both. Walker had grabbed a firearm in self-defense, believing that the intruders had broken in, and they fired towards the men entering. The men that had entered Taylor and Walker's residence fired back, wounding Taylor at least 5 times. Walker dialed 911 and reported that his door was kicked down and his girlfriend had been shot. Louisville police had conducted a no-knock warrant for a drug investigation, allowing officers to enter into Taylor's and Walker's residence without announcing themselves first. Police believe 2 men selling drugs more than 10 miles away from Taylor's apartment had received a package at her address. No drugs were found in her residence, and the police had located the main suspect before conducting the warrant. From this incident, Walker was charged with attempted murder of a police officer, but the charges were dropped less than 2 months later. Qualified immunity has played a role in shielding these officers from civil accountability. Although there is a strong argument that the actions of the police officers involved in Breonna Taylor's case violated her Fourth Amendment rights against unreasonable searches and seizures, as well as her right to life, it is difficult to overcome qualified immunity in the court of law. This doctrine makes it challenging for victims of police misconduct, like Breonna Taylor's family, to hold officers accountable in civil court. However, in a fair and just society, shouldn't those who are entrusted with enforcing the law be held to the same standard as everybody else? The controversy surrounding qualified immunity in law enforcement has spanned several decades, but has gained traction in recent years due to high-profile cases of police misconduct. What is designed to protect government officials from frivolous lawsuits has morphed into a formidable obstruction of justice. Today, I will present to you the origins, evolutions of qualified immunity, its impact it has on police accountability, and how to address these issues in law enforcement. First, you need to know the origins of qualified immunity and how it has evolved. In October of 2023, the Federal Bureau of Investigation, on their Qualified Immunity Today page within the Law Enforcement Bulletin, explains qualified immunity is a legal defense safeguarding law enforcement officers from personal liability in the execution of their duties. Qualified immunity is a legal doctrine that shields government officials, including police officers, from civil liability. It protects officials from being sued for damages unless their actions violate established constitutional rights. The doctrine is meant to strike a balance between protecting government officials to be accountable and holding them accountable for misconduct. Qualified immunity applies to discretionary actions performed within the scope of official duties. To overcome qualified immunity, plaintiffs must show that the official conduct has violated established constitutional rights. Courts determine whether a violated right is clearly established by analyzing prior case laws and whether the official's actions were objectively reasonable. Qualified immunity is often raised as a defense in alleged police brutality, excessive force, and other civil rights violations. Being protected by qualified immunity does not protect officials from criminal prosecution. It only applies to civil lawsuits seeking monetary damages. Qualified immunity has been used in a spectrum of cases engaging in misconduct such as fatal shootings, stealing, and sexual misconduct. According to the article from the American Bar Association, Qualified Immunity, in December 2020, highlights the foundational landmark court cases. In 1871, the Supreme Court had laid the groundwork for qualified immunity through its interpretation of the Civil Rights Act of 1871, aimed at combating attacks on African Americans by white supremacist groups. In 1967, the Supreme Court case, Pearson v. Ray, established a good faith defense to protect officials challenged under Section 1983. Qualified immunity commonly occurs in civil rights cases, notably under 42 United States Code, Section 1983, and Bivens v. 6 unknown named agents in 1971, allowing for plaintiffs to seek damages for unconstitutional violations by state or federal officials. Harlow v. Fitzgerald in 1982 shifted the focus of qualified immunity to the objective legality rather than the subjective intent of public officials. Harlow v. Fitzgerald expanded the qualified immunity by establishing good faith in a clearly established law. According to the UCLA magazine in fall of 2020, What Happens If We Eliminate Qualified Immunity by Joanna Schwartz, the definitive clearly established law has continued to change over the years. The interpretation and application of qualified immunity continues to evolve, displaying the continued debate of this controversial legal application in changing societal norms. The impact of qualified immunity remains one of the most central issues in civil rights cases, influencing the determination of government liability and individual rights. The recent Supreme Court cases have changed the parameters of qualified immunity. Notable cases and precedents in the 2000s are Saucier v. Kratz in 2001. It centered around military officers' detainment during a protest of animal rights, resulting in a lawsuit over Fourth Amendment. The court case established a two-step inquiry for government officials. In Pearson v. Callahan in 2009, it revolved around the consent once removed, where opening a door for an undercover officer would imply consent for additional officers without a warrant, challenging Fourth Amendment protections. The defendants, members of a narcotics task force, were sued for violating Fourth Amendment rights, invoking qualified immunity as a defense. The two-step inquiry was overturned and granted lower courts more discretion. Understanding the modern challenges of qualified immunity. Qualified immunity only shields actions deemed discretionary rather than ministerial. This means officials exercising judgment determine the best course of action. Ministerial acts are clerical, requiring that officials perform these actions irrespective of their own opinion. Even ministerial tasks may involve some discretion, but this may not meet the requirements of qualified immunity. Despite several cases awaiting Supreme Court decisions involving qualified immunity in 2020, the court has decided against revisiting the doctrine in June 2020. While qualified immunity is a doctrine of federal laws, some states have implemented modifications or restrictions, like the state of Colorado. It has become the first state to remove qualified immunity as a defense for law enforcement officers through the Enhanced Law Enforcement Act in 2020. Civil rights organizations and advocacy groups launched public awareness campaigns beginning in 2010. The heightened public scrutiny of qualified immunity is due to the perceived role of protecting law enforcement officers and the accountability from the state. Numerous legal challenges were filed against qualified immunity, usually by plaintiffs alleging violations of their constitutional rights. Qualified immunity is one of the most famous legal doctrines, receiving extensive media coverage, influencing opinions and understandings of it. Why do the contexts of qualified immunity change so frequently? Legal interpretation and precedent, a judicially created doctrine, means its application and interpretation can constantly evolve. As new cases are brought before various courts, judges may interpret the doctrine differently, leading to shifts in its application. Societal norms and values influence the way laws are perceived and applied. Heightened public awareness of police misconduct in recent years from both sides of the political spectrum has questioned police accountability. Proposals for reform of qualified immunity constantly influence public outcries and shifts in public dynamic. Public activism by organizations and legal professions influence policymakers through litigation, public awareness campaigns, and public opinion. Landmark cases and court decisions in high-profile cases have a significant impact on their application. As new cases are adjudicated and precedences are set in higher courts, the lower court's understanding of qualified immunity evolves and is constantly redefined. The changing public opinion and perceptions of justice and the role of law enforcement in recent years has called to changes for qualified immunity. Now you understand how qualified immunity has begun and evolved, let's explore potential pathways to address these issues. To address these complexities within qualified immunity and its implications, it's important to understand why it's an issue and the pathways for resolutions. Why has qualified immunity become an issue in recent years? The rise of high-profile cases involving police misconduct has drawn attention, amplified by the widespread media coverages about the role of protections from these legal repercussions. Racial justice movements like Black Lives Matter have shed light on the biases and brutality within law enforcement, demanding for reforms. Changes in technology, like the availability of camera phones today, give citizens the ability to record interactions in law enforcement, providing evidence of alleged misconduct in the hands of citizens. The erosion of public trust in law enforcement has contributed to the political polarization and divisiveness. The political nature of judicial appointments, particularly at federal level, can influence the composition of courts and the interpretation of qualified immunity. Public opinion on qualified immunity is often influenced by political narratives and electoral dynamics, with politicians tailoring their stances to align with constituents' views, especially during election cycles. Changes in presidential administrations can lead to shifts in policies and guidance on qualified immunity, reflecting political priorities of the incumbent administration, especially with the influences of campaign finance and lobbying efforts by special interest groups, which include law enforcement unions and civil rights organizations. Pathways to address qualified immunity. Policymakers and politicians can introduce legislation at federal and state levels aimed at abolishing qualified immunity. Amending these existing statutes can hold government officials accountable. Training and accountability measures. Developing training programs for police focused on constitutional rights, ethical conduct, and de-escalation techniques. Establish independent oversight boards to review allegations of misconduct. Implementing public online reporting, statistics to track the use of force, civilian complaints, and disciplinary actions by each agency. Increasing community engagement to encourage dialogue between the community and law enforcement. The article, "The Cops Who Had Sicked a Dog on a Surrendered Suspect Got Qualified Immunity" by Billy Binion of the Reason magazine in June 2020 explains multiple court cases that were thrown out over qualified immunity, including Corbett v. Vickers in 2019. The case pertained to a cop who shot and killed a family dog in front of 6 children while they were detained by firearms due to a criminal suspect wandering in the area. The same article, that of the even most right-wing members of the Supreme Court, like Justice Clarence Thomas, wanted to hear cases involving qualified immunity, like Baxter versus Braceley in 2018, a case where cops deployed a police dog on a suspect while he was surrendering on the ground with his hands held up. Courts have the power to reinterpret or overturn qualified immunity. Landmark decisions may be made by appellate and Supreme Courts, which can establish new legal standards or abolish qualified immunity. Public education can raise awareness about the implications of qualified immunity. Collaboration between law enforcement, politicians, and civil rights organizations can help find common ground and overcome obstacles to abolishment. On June 15, 2020, the summary disposition of the Supreme Court notes that Justice Clarence Thomas doubts the validity of qualified immunity jurisprudence in the section of the United States Code. The section highlights that any person who deprives another of their rights secured by the Constitution shall be held liable to the injured party. Exploring other legal protections, such as insurance-based liability, can provide avenues for compensating victims of government misconduct while protecting individual officers from personal financial liability. Studying legal doctrines and experiences of other countries have abolished or reformed similar doctrines could provide practices for addressing qualified immunity. Now we've explored the history and its implications, let's consider steps to reform. Qualified immunity should be abolished because we live in a country with an impartial court system, and the doctrine of qualified immunity allows police officers to avoid judicial consequences. The scope of qualified immunity. Less common than law enforcement, qualified immunity also protects against public school teachers, social workers, and public health officials. Qualified immunity extends to judges, prosecutors who are sued for actions within their official capacity. While qualified immunity is most commonly associated with law enforcement, it serves as a protection for government employees' actions taken in good faith. Common defenses from lawmakers. Law enforcement officers have the potential to fail bankruptcy if qualified immunity is abolished. If abolished, a slew of frivolous lawsuits will emerge, and law enforcement will need protections to properly do their jobs. Abolishment of qualified immunity will make law enforcement ineffective. Debunking law enforcement officers' defenses. Lawmakers' defenses. Law enforcement officers are always indemnified, which is a practice that shields officers from financial liability regardless of qualified immunity. Police officers on trial for violating constitutional rights of individuals would not pay for the lawyer defending them. The city or state an officer is employed with pays for police misconducts using taxpayer money. Procedural safeguards exist to allow courts to throw out cases that do not have any value or substance within the early stages. Along with safeguards of protecting the courts from frivolous lawsuits, lawyers will not take on cases that are wasteful of the court's time. Qualified immunity only protects government officials who break the law. Therefore, the need to have qualified immunity is alarming. According to the Legal Defense Fund article, Debunking Myths about Qualified Immunity and Examining Its Dangerous Realities of January 19, 2023, law enforcement officers benefit from broad legal protections in both civil and criminal legal proceedings. Along with being indemnified, officers benefit from the doctrine of sovereign immunity, which shields certain lawsuits within the scope of their duties. With indemnification providing coverage for legal expenses and damages, and sovereign immunity shielding law enforcement officers from specific lawsuits, what rationale exists for advocating for additional protections for police officers? Existing protections for law enforcement. The Fourth Amendment shields law enforcement officers already by protecting officers' actions that are reasonable under the circumstances during searches and seizures. Collective bargaining agreements and legal defense funds between law enforcement agencies and unions protect law enforcement's rights during disciplinary procedures and provide financial assistance. Over 15 states, Florida included, have enacted legislation to create a Bill of Rights exclusively for law enforcement. This Bill of Rights protects officers from unreasonable investigation and procedures. Strategies to abolish qualified immunity. Raise awareness, whether it's social media, community organizations, or personal networks, sparking conversations of reform and alternatives in our justice system. Reach out to your elected representatives at local, state, and federal level to express your concerns and urge them to support reform efforts. Participate in community initiatives aimed at accountability and reform in policing. This can involve attending community meetings and supporting local activism efforts. Staying informed of ongoing legal challenges in court cases relating to qualified immunity. Supporting academic research that examines the legal, social, and economic consequences of qualified immunity that provide ideas for evidence-based reform. Today I explain the history of qualified immunity, the impact it has on police accountability, and why it's important to abolish this legal doctrine. As I mentioned earlier, the controversy over qualified immunity has spanned several decades, but has gained traction in recent years due to high-profile cases of police misconduct. What was designed to protect government officials from frivolous lawsuits has morphed into an obstruction of justice. Throughout the United States, there are hundreds of police agencies whose primary responsibility is to uphold the rule of law, ensure public safety, and promote the well-being of the communities they serve. However, legal protections created to help execute these duties, such as qualified immunity, have shielded law enforcement officers from facing consequences for far too long. When officers engage in misconduct, it not only affects the victims, but it also affects the community through legal settlements and payouts funded by taxpayers. It is a morally imperative step for citizens and lawmakers to end qualified immunity so that officers can finally be held accountable for the harm they cause and the lives they ruin. Police officers have gone away with harming pets, people in their beds, and surrendering suspects. If the United States system is generally fair and impartial, then it's time to take action and abolish qualified immunity. Abolishing qualified immunity is not only a legal issue, but it's an ethical step forward for achieving justice for everyone in our society. As Thurgood Marshall once said, "Where you see wrong or inequality or injustice, speak out, because this is your country, this is your democracy. Make it, protect it, pass it on." So our questions for discussion are, do you think we should abolish qualified immunity? Should the issue of qualified immunity be left for states to decide? And how would you feel if a friend or a family member was adversely affected by qualified immunity? And what steps do you think should be taken to ensure a fair and just outcome for all involved?